Our next speaker is Orsola Lamberti, who is an Italian qualified lawyer with experience in plant variety rights and trademark law, and who works in both the private and public sector. She currently works as a legal advisor for the Community Plant Variety Office. Orsola, welcome to make your presentation.
Thank you, Wendy, if I may. I will share my screen in a second. I hope you can see it. Okay. Yeah. Do you see it?
Yes, we can.
That's fantastic. Okay, thank you for the floor. Today I have the very ambitious task of explaining two topics in a very brief time frame. The first topic is giving you some basics on the community plant variety right system in the European Union, of course, but also on an international scale. And the second topic is more about the interplay between this system and the Nagoya Protocol and the access to genetic resources that was mentioned before by Mary. Okay. Okay. As a lawyer, I have to start from the legal basis, so bear with me for a few minutes here. What's important to remember here is that we have an international convention, the UPOP Convention, that is the base of the system. This was put in place initially in the 60s, but the European Union is a signatory of the 1991 Act, the latest act. Well, it's already 30 years old, but it is the latest. It's an international organization with seat in Geneva, actually has a seat in WIPO, in the WIPO building. So maybe Miss Bellamy and Miss Caminero have seen the offices of UPOP, they're there. And the other legal basis that is important for today's presentation is what we call the basic regulation at the Community Plant Variety Office. It's a regulation 2100 from 1994 that sets in place for the first time this system in the European Union. The main characteristics of the system, first of all, is a sui generis system, which means it's not a patent, it's not a design, it's not a trademark, it's a separate exclusive right for the plant breeder that lasts, as you can see on this slide, 25 or 30 years from the date of grant. This is the difference with patents that is granted from the dates of application. So it's a very long monopoly, if I may, but it has its own good reasons to exist. And the reason is the one that is overarching the entire IP system, which is to encourage and support progress in technology, in this case in plant breeding. As we were saying, it's based on the UPOP Convention, and the UPOP conventions, like the basic regulation, include all the botanical genera and species. So if there is an innovation, if there is something new in the plant breeding sector, you can protect it. Doesn't matter if it's for food consumption or an ornamental. This will be relevant in a second. We will see why. At the European Union level, we provide a protection that has a uniform effect according to Article 2 of the basic regulation. What does it mean? It means that with one application, one technical examination, we will see what it means in a second, and one decision on the grant, it is possible to have protection in all the 27 member states of the European Union. This is the same system that we see in trademarks and community designs at the European Union level. This also means that the grant, as we were saying before, the transfer and the termination of the right is done on a uniform basis. There is no possibility of double protection, so the European Union citizens or breeders, innovators can choose between a national protection or a European Union level protection. It really depends on their strategy or what their company does. But it is not possible to have them both. So one overlaps with the other and becomes ineffective when the European Union protection is in place. The system is managed by the Community Plant Variety Office, for whom I have the honor to work. It's a European Union agency that deals with the system and organizes the technical examination. So I'm talking about technical examination, which is the assessment of the first three of the requirements for protection. We're not going to details, but it is important to understand the nature of this requirement to understand also the link with traditional knowledge. We have the first three requirements, the so-called DUS, distinctness, uniformity, and stability. These are technical requirements of the plant variety that can be observed on the plant. And we have novelty, which is a commercial novelty, not to be confused with novelty in patents. This means that the plant variety should not have been put on the market at the date of the application. And finally, a variety denomination, a generic designation of the variety that helps us to identify the little bag of seeds that we see on the market. We need to name the new variety. The definition of the three technical requirement is here. What's important for me is that we understand the concept of distinctness. Distinctness can be, we can draw a parallel with patent and consider it as the novelty of patent and the relationship with the prior art. What does it mean? It means that the candidate variety, a variety is distinct when it's clearly distinguishable from other varieties of common knowledge at the time of filing of the application. What does it mean? It means that for being protected, for obtaining a monopoly and exclusive right, the breeder needs to present something that hasn't been seen in the common knowledge. The common knowledge includes plant varieties known in the entire world, and it also includes private collection, also everything that it can be seen in literature. So it doesn't have to be a mainstream variety to be part of the common knowledge. And what's very important for me to convey today is that the common knowledge, the traditional knowledge is part of the common knowledge. So something that is part of the traditional knowledge cannot be protected by a plant variety right, but it has to be known by the examiner so that it can compare it. It can use it as prior art if you want to keep using this parallel with patents. We mentioned before, and Mary gave a very nice overview on the ABS system. I will not go into the detail of that because that's basically not my job. I can talk about the IP rights part. So ABS measures, as she mentioned, do not really address intellectual property in the European Union, but the provisions of the UPOV or the basic regulation, the Community Plant Variety Rights System, should be interpreted consistently with the other international treaties. This is a basic rule that we can see in the Nagoya Protocol. We also see it in the so-called FAO treaty that she also mentioned, the Plant Treaty. And so they all have to, they're not mutually exclusive, and they have to be interpreted in a way that the aims and the objectives of all of them are reached. So a few thoughts about the interplay between these international treaties and the plant variety protection system in the European Union. So ABS measures are based on Article 192 of the Treaty on the Functioning of the European Union. Once again, this doesn't address really intellectual property in the European Union and is left to the negotiations of the parties. We have to repeat this, and it's really important for me that I manage to convey this message to you. Traditional knowledge cannot be protected under any intellectual property right. It's the new variety that is based on traditional knowledge that can be protected. But this, between the traditional knowledge and the new variety, we have 10, 15 years of highly skilled work and investment of time and economic resources. So it's something completely new. Access to genetic resources is essential for plant breeding. Unlike what happens for mechanical inventions where something can be somehow made, in case of plants, to create a new plant, you need a starting plant. So you do need, as a breeder, access to genetic resources. And this has to be done, of course, according to the Nagoya Protocol that, as we were mentioning before, is managed by the member states of the European Union. I would also like to mention here technology transfer, which is really what connects and what fills the gap between the breeders and the farmers, the growers. No? Because we talked about the interest of the innovator, the one who put on the market a new variety, but there are also the interest of those who grow that variety, who may use that variety as a food product. And we will see in a second how In some countries, plant variety offices also work as checkpoints. This is not the case for the European Union, as it was very well explained before, but is the case, for instance, in Ecuador. Plant variety offices, when it comes to traditional knowledge, can require to the breeder, to the innovator, to disclose the origin of the material. So to tell the plant variety office before getting the protection where this material came from. We have the possibility to request this information. However, the compliance with the ABS cannot be considered as a requirement for registration. Why? Because in the UPOV Convention, this is not a requirement for registration. So it would mean add a further layer that is not allowed by the convention. However, states can decide to implement and to require this kind of information on the basis of other general interest reasons. And these are my two last slides, and are about the FAO treaty, the plant treaty. As we saw before, genetic resources are the building blocks of plant variety innovation. They're essential. We cannot make a plant. We can only make a plant from another plant. The FAO treaty is very peculiar in this case because it covers only a fraction of the genera and species that are covered by the UPOV conventions. We saw before that there is no limitation to the species that can be protected from IP rights. So we also consider worth supporting innovation in the field of ornamentals, for instance. No? There is a general reference in the treaty to IP protection. It's just said that intellectual property cannot limit the access to genetic resources. And this is the case because intellectual property does not really have as a scope, as an objective scope, the genetic resources. The genetic resources is the starting point for the innovation. And of course, IP protection does not exclude the sustainable use of genetic resources. And actually what we observe right now is a focus on the breeding sector of the innovation more and more on sustainable varieties that can produce more with less, or have a lesser impact on the environment. I would also like to mention farmers' rights. We did not mention those rights, and they are extremely important, even if not defined in the FAO treaty. This is addressed not directly from the UPOV Convention and the Basic Regulation for the simple reason that this convention was written to protect breeders, not the farmers. So they're not the main character of this story, we can say. This doesn't mean that their rights are not important and they cannot be respected. Actually, the basic regulation provides for an exception that is called farm safe seeds, Article 14 of the basic regulation, that allows the reissuing of seeds in the holding of the farmer. I would also like to inform you that in the European Union, in the Common Catalogue for Agricultural Species, this includes conservation variety. The Common Catalogue is a register of variety that have to be include those varieties that can be put on the market because they are food for the European Union citizens, and they have and they're safe to eat. Well, this catalog, the Common Catalogue, also includes conservation varieties, which includes land races or those varieties that are not commercially viable, etc. This also includes preservation mixtures, which are not even a variety. It's a mix of species that are very useful for the environment and also need to be registered. And finally, last slide, I promise, we also have to consider that the basic regulation also includes some limitation to the intellectual property right. We have an exclusive right, but no right, especially except some constitutional rights, is absolute. So there are some exceptions, some limitations. We have acts done for privately, acts done for private and non-commercial purpose are not subject to this to the scope of the right. Same thing for the experimental purpose. And finally, in Article 13 of this basic regulation, we have this closing clause that is very interesting. I leave you the time to read it. And the point here is that we do want to protect breeders, but their protection cannot go against a series of public interests: the environment, the protection of industrial and commercial property, competition, etc. This includes, of course, also the rights of the farmers and growers. And that's it. Thank you for your attention.